Not that that's a big deal. He's not sensitive to it, but when I looked at it.
Andrew, can you put the slides up, the presentation?
Yeah.
It's on the desktop.
Okay. You ready, Joe?
Yes.
Good morning, everyone. Welcome. We're really looking forward to this presentation. As we all know, in 5 days we have some new rules of professional conduct, and we are here to sort of highlight what the most important changes may be and go over what are new rules, new in California anyway, and what are significant changes or important changes to the existing rules, which some of us will be referring to as the former rules, because 5 days from now they will be former. So our current rules will be former in 5 days. So if you hear us say, refer to the old numbering, you know that we're talking about the rules that are about to change as we go through the presentation. So first let me briefly introduce, we'll each introduce ourselves, starting from my far right, Teresa Schmidt.
My practice is in the area of legal ethics consulting, and also in consulting with bar associations and regulatory systems, professional regulatory systems. My background includes about 10 years working for the Office of the Chief Trial Counsel in Los Angeles, and I'm also the past executive director of 2 state bar associations, the State Bar of Arizona and the Oregon State Bar.
Hi, my name is Kevin Moore. I'm a professor at Western State College of Law in Irvine, California. I teach contracts, intellectual property, professional responsibility, and law practice management. My connection with the State Bar goes back quite a ways. I've been a member of COPRAC, the Committee on Professional Responsibility of Conduct, and a former chair. I was the reporter consultant to both the first commission and the second commission that drafted these rules. And at the tail end, I was a member of what might be called the extended commission, which was around to answer any questions from the Supreme Court that may come up.
Good morning, my name is Eric Deitz. I'm a partner in the Southern California offices of Gordon Reese, Scully Mansakani. I'm also a current member of COPRAC. My practice consists primarily of representing professionals in professional liability matters, as well as professional responsibility counseling, in addition to commercial litigation and employment law.
And I'm Suzanne Burke Spencer. I'm a managing shareholder of Saul Spencer Allison Krieger. And my primary area of practice is also attorney ethics and professional negligence. And I am immediately former member of COPRAC and was also a former chair. So let's just jump right in. We've got a lot of material to cover. I'll tell you up front that there's more information in the materials, the written materials, and even, frankly, more information on our PowerPoint slides than we can actually cover. There's a lot here. We're trying to give you as much information as we can for your future reference, as much as whatever we can cover today. We will ask that you hold questions. We'll have a break, and before the break, hopefully we'll have time to take questions. But do make a note of whatever questions may come to your mind, and then we'll take questions at the end, if we have time, and certainly by the end of the session. So we'll start first with discussing a little bit about how we got here with the new rules, and we'll ask Kevin to briefly address that.
Okay, I'll try and do this in a time-lapse fashion so that you're not here for the next 18 years that I spent working on the commission. First thing I want to talk about was the charter of the second commission. And I'm going to have to explain a little bit before I get into that as to the historical events that led to the second commission. The first commission was appointed in 2001. And the first commission was made up of lawyers who had been involved in the drafting of what are the current rules, soon to be former rules. They came from the late 1980s, early 1990s, and over half the members of the first commission were from that, I guess we call the prehistoric commission, rules commission. They drafted a set of rules. It was a long, involved process. They were finally adopted by the Board of Governors, then the Board of Governors is what the Board of Trustees was called, in 2010. And over the next several years, the bar was working to submit rules one at a time to the Supreme Court. That was what the Supreme Court had requested. In 2014, the Supreme Court pulled the plug on that process and said that they wanted a new commission to be appointed. And the Supreme Court provided a charter that was drafted with the cooperation of the State Bar of California. And there were 5 points to the charter. First, the rules were to promote confidence in the legal profession and the administration of justice, and also, very importantly, intended to protect the public. Now, when you hear protect the public, primarily what protect the public means is protect the legal consuming public, that is the clients. So right away, right off, you know that the California rules are intended to be client protective. Secondly, the Supreme Court called the attention to the State Bar and future commission members that traditionally the rules in California are disciplinary rules. They're intended to be used in the disciplinary process. And therefore, they should be prohibitory. They should not be aspirational. They shouldn't use the word should. They shouldn't be permissive. They shouldn't be telling you, well, these are things you may do. If you want to explain that, you might put it in the comments, but we'll come back to that in a second. Third, you should reduce any unnecessary difference between the California rules and the rules of other jurisdictions. And a big difference in the California rules. California was unique. Lawyers from other parts of the country would just look and say, oh, California, yeah, they have their own rules, and wouldn't pay much attention to what California was doing in respect to professional responsibility. One of the unnecessary differences is probably the California rule number system, and that is something that the Second Commission took to heart and came up with a set of rules that now parallels the model rule numbering system. I'll come back to that in a second. Fourth, the rule should facilitate compliance and with the law. They're not strictly 10 Commandment rules. I mean, they're not just prohibitory. They should provide some guidance. So the rules should be sufficiently, I hate using this word, but I'll use it, sufficiently clear and unambiguous so that folks understand what their responsibilities are and what they need to do in order to both comply with the law themselves and assist their clients in complying with the law. Finally, all substantive information was to appear in the black letter text of the law. That is, any prohibitions, any duties must appear in the black letter text, and the comments, which should be used sparingly, only to elucidate the rules, to clarify the scope of the rule or the application of the rule. The comments should not expand the rule. They should not include any extra duties. All of that pretty much happened. The first commission came up with a set of rules that tracked the ABA rule numbering system, but it had over 500 comments attached to it. The new rules have substantially fewer comments, somewhere between, I guess, between 100 and 200. I can't tell you exactly how many there are. I haven't actually counted it. We took the 46 rules that exist currently. How about this for an anomaly? They exist currently in the former rules. And those 46 rules were pretty much maintained in some fashion or form going forward in the new rules. Plus, there is an additional 23 rules that show up in the rules. There are 69 rules total in the new rules with which you are going to need to become familiar. These were sent up to the Supreme Court in March of 2007. The State Bar and the Commission met its deadline by 1 day. The rules that were submitted occupied something like 5 large banker boxes of paper that was submitted with the Supreme Court. This is all the background materials, all the deliberations of the Commission went up to the Supreme Court. The Supreme Court reviewed them, and about a little over, 13 months later, at the beginning of May of this year, the Supreme Court returned the rules, and the Supreme Court pretty much adopted all the rules with one exception. We'll talk about that briefly in a little bit. That's Rule 1.14, which is a client with diminished capacity. And the Supreme Court also suggested a modification to a second rule, Rule 1.2.1, which the extended commission worked on for another couple, 3 months, and that came back September 26th. The Supreme Court finally agreed with changes. They suggested changes, the extended commission suggested some more changes, and it came back, and I believe Teresa will be discussing that in a little while. Now, there's one caveat I would like to make. The overall changes, yes, it's the model rule numbering system. It's the model rule organization, format, and style. But these are not the model rules, please. You cannot substitute the American Bar Association's model rules for our rules because there are significant differences, and that's going to be a focus of our discussion. Sure, we substituted lawyer for the word member in the rules. That's not that big a deal. A big important point to note is that you'll see on the slides we're going to be running through throughout our program today, is you'll see words with an asterisk next to it. I want to call your attention to that because an asterisk means that the rule is defined in Rule 1.0.1. That's the terminology rule. Keep that rule handy during our discussion. As we're discussing a particular term, you might want to take a look at the rule that has the meaning of the rule. Now, although there is a general terminology section that applies to definitions that appear in all of the rules, there are about another 30 or 40 definitions that appear in specific rules that are specific to that rule. So you have to be aware that there are definitions strewn throughout the rules. They are not just in Rule 1.0.1. A couple more points I want to make. Remember, we're California. Yes, we're different. So the rules are not the sole source of regulation for lawyers in California. We also have the State Bar Act, Business and Professions Code 6000 et sec. You have to be aware of that there are numerous provisions in the State Bar Act, and we'll talk about some of those during the course of our program today. You'll also find provisions in the probate code, you'll find provisions in the penal code, you'll find provisions in the evidence code, and the Code of Civil Procedure, all of which govern lawyers' conduct. I can't emphasize that enough. Another point to remember is that there is a rich case law of lawyers, of the law of lawyering or lawyer professional responsibility and risk management in California. In fact, although we've expanded the conflicts rules, the conflicts rules by themselves are not going to be sufficient to guide you in complying with your obligations. You're going to have to consult a case law on that. In many instances, these new rules are not really new rules because the duties were there. The duties resided in the case law, except they weren't easily accessible by lawyers unless you knew where to look. So now we've tried to, one reason why the rules are so much longer than the former rules is because we have incorporated into the rules a lot of material that previously existed only in the case law. I would like to just mention one last thing, which I tell my students at the beginning of the semester. As you look at a rule, consider the 5 Ps, meaning protect. There are 5 protections involved in the rules. First, protect the client. This is your duties as an advisor and advocate acting on behalf of the client. The second is to protect the system of justice. This is your role as a lawyer, as an officer of the court. Third, you protect the legal profession. You protect the integrity of the legal profession by your actions and the actions of every other lawyer. Fourth, protect the public. And fifth, and this may sound cynical, there may be a rule out there that you'll see, one of the purposes of it is to protect the lawyer. Now, it's not protecting the lawyer in that it's giving the lawyer a safe harbor necessarily, but it's protecting the lawyer in its providing explicit guidance on how to proceed. That in turn protects the client and it protects the legal profession and the system of justice. Those are the 5 Ps to keep in mind. Client, justice, system of justice, excuse me, legal profession, public, and lawyer. And as we're discussing these rules, think as to what is the main objective of this particular rule. How does it fit into that scheme of things?
Thank you, Kevin. And another interesting point on that with respect to the State Bar Act, with our new rules, the new rules now will conflict in some ways with the State Bar Act. So we will point that out when that comes up. But it's an interesting area, and we'll have to see what the legislature does, how that evolves as we move forward. So we've divided up the rules by subject matter, and we have we'll start with the ones most closely related to the lawyer-client relationship. We'll start with competence.
Thank you. I commend everyone for being here today, whether in person or via the web, for a number of reasons. You're getting the jump on the implementation of the rules, which, as Suzanne indicated, will become effective in about 5 days. You're also benefiting from receiving this particular handbook, which is a nice compendium and handy, and I would encourage you to make frequent reference to it, as well to the Business and Professions Code and other sections that we will call out as we go through some of the rules today. We're going to start with the rule of competence, which is 1.1, and I'd like to think this particular rule encompasses those 5 Ps that Kevin made reference to better than any other. It's not by accident that it is the first substantive rule, and as you might expect, given the public protection function that these rules serve, it's of the utmost importance. So keep that in mind as we go through and discuss a bit about 1.1, which is the former 3-110. In terms of the structure of 1.1, it retains much of the current rules, about to be former rules, structure, with the exception of diligence being a separate rule, which we'll discuss in a moment. It's worth noting that 1.1 is intended to address the conduct of the lawyer, him or herself. There are other rules that are specifically called out. 2 new rules in particular, 5.1 and 5.3, that impose an obligation to supervise in a managerial capacity or in a supervisory lawyer capacity, as well to do so with non-lawyer professionals. Also of significance, the definitions in terms of what constitutes competence are largely carried over, with the exception of gross negligence, which is added. The key takeaways from this are that a lawyer must act with competence, and that's defined as having the learning and skill and the mental, emotional, and physical ability reasonably necessary for the performance of such service. Obviously, given the public protection role of the rules of professional conduct, and recognizing some high-profile incidents that have occurred, as well as the changing dynamics of our profession, you should not diminish or ignore the second portion of the rule of competence regarding having the adequate mental, emotional, and physical ability reasonably necessary. And I would submit that if you are supervising other lawyers or other professionals within your office, keep that in mind as well. This particularly relates to workload, and while that is may have an element of risk management to it, it is an obligation that we have under the rules of professional conduct as well. In the event an attorney finds him or herself not able to adequately discharge the duty of competence, then there are some remedies available, provided those occur before the service is rendered. These include associating or consulting with another attorney or professional that the attorney reasonably believes is competent, acquiring new skills or knowledge in order to discharge the duty of competence, or referring the matter to another professional who has the requisite skill set and necessary competencies. That was referred to in a comment to 3-110. It's now part of the black letter of the rule. And then lastly, it's worth noting that what was also previously a comment is now included in the black letter, and that is the ability of an attorney to provide emergency services in the event that such services are necessary. But that's limited in scope and time. It's only to avoid harm to the client. So now we'll turn to Rule 1.3. As with 1.1, this is unwaivable. It is intended to address the conduct of the lawyer as opposed to those the lawyer is supervising. There is reference in the rule to 5.1 and 5.3. Diligence is defined as having the commitment and dedication to the client's interests that may be necessary to discharge the duty, and also requires that a lawyer not neglect or disregard or unduly delay. And that ties in with the rule that we'll be talking about a bit later, Rule 3.2, which is specifically intended to address delay of litigation. And as you can imagine, Supreme Court, First Rules Revision Commission, the Second Rules Revision Commission, the now Board of Trustees are all concerned generally with the public's perception of our legal profession and complaints with regard to the manner in which the provision of legal services occurs. So again, you can extrapolate from that. The RRC and the Supreme Court added these or highlighted these specific obligations with regard to being diligent, being persistent, and called those out to address that concern. So now we will turn to scope of representation.
And this is along the same lines. It's within the same group. And again, it's talking about the allocation of responsibility between lawyer and client. This is a new rule. We don't have a counterpart in the existing, soon-to-be former rules. I don't think that it's a change in the law with respect to this issue in terms of who gets to make what calls in the context of the attorney-client relationship. However, it's now in a disciplinary role. So again, we're increasing the sort of, number one, we're educating lawyers so that they know, the rules are so that they know what the law is, and it's in one place, because the concepts that are in this rule have been existent in the case law and in the law of fiduciary duty already, but it wasn't in a disciplinary rule. Now it's there. And so it also, however, means that you can be disciplined for violating it, whereas before, unlikely. So the scope of representation and allocation of authority rule talks about, number one, who's in charge of making decisions about the objectives of the employment of the representation, and that is the client. the lawyer must follow the client's decisions with respect to the objectives of the representation. Now, the means of achieving those objectives is shared between client and lawyer, and there the lawyer must reasonably consult with the client with respect to the means by which those objectives will be achieved. Now, I don't think that this changes some of the existing law where we talk about trial decisions and strategy about what witnesses to call at trial, and strategic decisions on legal strategy lie with the lawyer, and that will still be the case likely under this new rule. So the lawyer is still the captain of the ship, as some of the cases refer to it, with respect to making decisions about the specific legal strategy that will be employed. But they have to reasonably consult with the client, and note that here reasonably is one of those defined terms. It's an objective standard, reasonably prudent person. There is also an implied authorization aspect of this rule, which is not present in the existing. And what it really is about is saying that you have implied authorization to act for your client in order to achieve the objectives. And that is, there's a caveat on that with respect to the confidentiality rule. You don't have implied authorization to share confidential information that you think needs to be shared. That you can't do. That's always got to be specifically consented to by the client. But beyond that, other acts in the furtherance of the representation and within the scope of the representation, there's implied authorization that you have authority to act in that way. Remember, though, that you can never compromise a substantive right of the client without the client's consent. So this allocation is not going to allow you to, say, compromise your client's case without their consent. The rule on the decision on settlement always lies with the client, and that is still the case, and now it's expressly stated in this rule. The rule also addresses the ability to limit the scope of your representation. And as with existing law on this, it's now in a rule, which is that you can limit the scope of your representation, but only if it's reasonable under the circumstances. And so an example where it might not be reasonable is to, take on a litigation and say, I'll represent you, but I won't put on this particular defense. If that's not a reasonable way to limit your representation so that you can still provide competent representation, then you can't do it. You can limit it, for example, I'm not going to pursue claims for workers' compensation, I'm doing this employment law case, I'm not going to pursue a claim for workers' compensation. You can limit your representation, but you do have to explain the limitation, and you have to explain what the limitation means to your client. Similar to the vein we're talking about in terms of the relationship between lawyer and client, we have Rule 1.2.1, which is formerly 3-210, and basically that is the rule that says you can't advise your client to violate the law. You can't insist your client in the violation of the law. We have a little bit more robust rule on this now, and it prohibits advising or assisting when you know that your client is engaged in a criminal or fraudulent act. That you can't do. You can explain the legal consequences to your client of your client's plans, even if the client is planning to violate the law. You can explain what the consequences are. You can't assist them. And you can explain the validity, scope, and meaning of any particular laws. And that can be part of your advice, even if you think that the client's purpose in asking you is because they're trying to find out how to evade that law. As long as you're not assisting them, you can still explain what the law is and what it requires. Where this has become a really interesting issue for lawyers in California in particular is what happens when the law, our law in California, conflicts with federal law. And this happens around the cannabis issue. It can happen around sanctuary city type immigration law, where our California laws maybe will run afoul of federal law or tribal law. And to try to address the quandary that a lawyer that is maybe advising a client that's engaged in the cannabis business, the Supreme Court has added, and the Rules Commission has worked on this comment 6, which went back and forth quite a bit and only recently was approved by the Supreme Court. So there was some talk. The Supreme Court asked for the Commission to go back and look at this comment again. Let's talk about how we can address this issue. Can lawyers or can't they advise clients in the cannabis industry? And without running afoul of advising the violation or assisting in the violation of the law. And so where the comment comes out and where the Commission and the State Supreme Court are with this is that you can advise a client about complying with California law. And that can include the California laws around the cannabis industry. It can include setting up, doing corporate law, for example, that has nothing to do necessarily with cannabis or not, but it's for a client that is engaged in that. And that is something that you can do. But you do have to explain, if you're going to be in this position, you must explain to the client that there is a conflict in the law and that their actual conduct may violate federal law. So you do have to explain to them that there is this conflict in the law and what the consequences may be. But you will be able to advise them on the California law and complying with California law. So it's a tricky it's a tricky line to walk, of course. But this is in there to give some cover, I think, for disciplinary purposes for lawyers that are trying to represent clients that are engaged in a legal act in California, but maybe not under federal law.
Yeah, if I could just tack on something to what Suzanne was discussing. If you look at the comment, you'll see that the word cannabis, neither the word cannabis nor marijuana is used in that comment. The comment is intended to more generally apply where there might be a conflict of laws. After all, we're in California. California tends to walk its own course at times, and we anticipated there would be other laws that might exist in the future. And we have our sanctuary laws are in conflict right now with the immigration laws of the United States. So it was written more generally. It started out as a marijuana comment, but then it was intended as a more general comment. Of course, the Daily Journal, in its headline, when the Supreme Court returned the rule with its approval, stated, "Supreme Court approves lawyer advice to marijuana growers," which kind of undercut our whole intent in drafting a general comment. Okay.
Well, they wanted people to read the article. Moving on. Right. Communication with clients.
Okay, I'm going to cover the communication with clients. As Eric mentioned at the beginning, the central rule in all these rules is probably the competence rule. The competence rule is, in a sense, the wheel that drives the delivery of legal services to your client. But if the competence and also the diligence rules are the wheels, the communication rule is the linchpin, that the wheels will come flying off unless there is the necessary communication that's made. The points I want to make about this rule, it looks like it's substantially expanded from former Rule 3500. And in a sense, it is. It lists what seems to be a lot more duties, but those duties have always existed in case law. In fact, if you look back, at one point there was no communication rule. There was no rule of professional conduct that stated a lawyer was obligated to communicate with his or her client. Nevertheless, lawyers were disciplined for failing to communicate, for neglecting their clients. And this is, I can't emphasize this point enough. A lot of what you see is required in the rule, and I'll go through each paragraph in turn, is really implied in all of the other rules. That's why I refer to it as a linchpin rule. Just as a quick example, Suzanne just explained Rule 1.2, the allocation of authority and responsibility between lawyer and client. Well, yes, the client gets to make all the decisions on the client's substantive rights. However, the lawyer is obligated to communicate or disclose sufficient information so that the client can make an informed decision as to the client's substantive rights. What is disclosure? Disclosure is a detailed explanation advising the client of the advantages and disadvantages of a particular course of action, but it's intended to give the client a sufficient amount of information so the client can make an informed choice. How do you deliver that sufficient information? You deliver it through communication with the client. And that is what this rule is all about. It's a very, very important rule. So I'll spend a little time talking about it. First, you need to disclose and inform the client of any decisions are made, say in a matter, so that the client can make an informed decision, informed choices as to how to proceed. Well, gee, you just lost a summary judgment motion that just cost you $150,000. Do you want to go on? Do you want to appeal this? I mean, this is sort of what this rule is trying to get at. That's A1. You have to consult with the client about the means and objectives of how you're going to proceed to achieve the client's, what means you're going to pursue in order to achieve the client's objectives. Again, the client makes the decision about what those objectives are going to be. You are going to be the one who comes up with the means to achieve the objectives, but you need to communicate those reasonably with the client. The 8 sub 3, that paragraph is pretty much current rule 3500, which talks about you must disclose significant developments and provide the client upon request with significant documents. Now, this gives rise to what is probably my favorite comment in the rules. Remember, the Supreme Court directed the Commission to use comments sparingly and not to expand the rule. If you look at comment 1 to Rule 1.4, the last sentence, people always ask, well, what is a significant development? How do I know if it's a significant development? Well, we tell you. Whether a particular development is significant will generally depend on the surrounding facts and circumstances, which is probably no help whatsoever to a lawyer who's trying to decide, do I have to communicate a particular item of information? This was actually, and I want to talk a little bit about this, this was actually taken from the First Commission. But the First Commission's comment was followed by about 12 lines of text that explained gave an example of what was a significant development. In that case, well, the lead lawyer has left the firm and is going someplace else. Now, that one who's handling your matter, the one you've been talking with, that lawyer has left the firm, that sounds like it's a significant development, and maybe the client should know about that. What might not be a significant development? It might be that you have granted the other side a 2-week continuance in order for them to file a response. You stipulated to continuance. That's something you don't necessarily need the client's consent to do. As Suzanne mentioned, you're the one who is the captain of the ship, and you are operating the ship and determining the best course to take. On the other hand, if granting that continuance, for example, if the judge said, I'm not going to grant any more continuances, and you're going to go ahead and file that could prejudice your client's case, then that's something that you shouldn't do. That was in the former one, but I'm just giving you an example of the previous commission had written much more expansive comments. The second commission tried to narrow those comments substantially. In some instances, you'll see comments that, well, why is this here? Why are they just stating the obvious? And in many instances, it was taking what the first commission had done. And generally speaking, all of the rules, the second commission began with the first commission's take on the model rules. That's an important point to make. They weren't looking at the model rules or the current rules so much as the starting point was typically the first condition like that. A4 talks about limitations. You have to disclose certain limitations, just as you're required to do so under Rule 1.2. There are certain things that I can't assist you with. And that's going to be, well, that would be 1.2.1. I can't assist you in the violation of a law. Paragraph B is arguably one of the most important as the linchpin concept that I just discussed. And that is, the client has to make certain decisions. That's set out in Rule 1.2. How does the client make an informed decision? It's going to be make an informed decision based on the advice that you provide the lawyer. So you need to communicate sufficient information, sufficient advice, so that the client is capable of making a decision that is informed. Keep in mind, the client's decision is informed only to the extent that there has been sufficient disclosure. Always keep that in mind. That's a very, very important concept to remember. Delay, imminent harm. There are certain things that maybe if you communicate it to the client, if your client's in a vulnerable mental state, this rule provides you with the ability to make that call in some instances. You have the authority in certain instances to withhold information. It may be a significant development, but you can withhold it for fear that it might cause the client to take a rash action. However, there's a comment to the rule, and you might just want to make a note of this, that says if you withdraw from representing the client, you're still going to have to provide the client with that information upon withdrawal. And finally, you need to be aware that under certain statutes, particularly under the penal code, you're prohibited from disclosing certain information to the client. So this isn't a ticket to you to disclose information to the client that is otherwise prohibited. For example, you can't disclose addresses of witnesses in a criminal proceeding. Those are things that you are prohibited from disclosing, and you are provided with citations in the comments to those kinds of statutes. These aren't meant to be exclusive. We're not trying to cover the entire territory. We're just giving you examples. Be aware that in some instances there may be information that you are prohibited from disclosing. It may be by statute, or it may be because of a contractual obligation that you've signed a non-disclosure agreement for attorney's eyes only, then you can't disclose it to the client. And we're going to move on now to my favorite topics.
Speaking of things that you can't disclose, confidentiality. Teresa.
Okay. It is probably, now you're going to hear from all of us, the rule we happen to be talking about at the moment is the most important rule here. But the fact is that this one actually defines California lawyers in a way that a lot of them don't. We're different on almost everything. But the idea of confidentiality, you can't really appreciate the California lawyer's notion of confidentiality without going all the way back to the B&P Code, 6068, duties of an attorney, which was enacted originally in 1939. And the concept of confidentiality that was embedded in that law never changed substantively. And the language of that, and the language of the B&P Code, is that a lawyer shall preserve the confidences and secrets of a client at every peril, quote unquote, at every peril to himself or herself. And it is based on that Rule 1.6 and prior to it, former Rule 3-100 arose. At every peril, every time I read that, I think I get a picture of a lawyer tied to a chair with bamboo under the fingernails. And you actually, if you think of it in using client information, and you think of having client information in your possession, and not just confidence is something the client told you, but something you might have learned, a secret of the client in the course of the representation. Both of those things are protected under 6068. And as a result, when the rule refers to This rule is about all of the protections that occur under 6068E. That's the level of confidentiality we're talking about. There is a difference, which attorneys often don't completely appreciate, between attorney-client privilege and confidentiality. Attorney-client privilege is an evidentiary standard. Confidentiality is much more of an absolute standard. It's a professional responsibility. So be sure not to confuse the two. Privilege will be defined by evidentiary law. It will be defined perhaps by contract, but it does not, but your responsibility to the client is about confidentiality, and it is going to be embedded in the B&B code and this rule. It of course, in almost everything, almost, not completely, in almost everything, there is having to do with client confidentiality. There's a possibility that the client can consent to it. And remember, consent is one of those words, informed consent is one of those words with an asterisk. And there's going to be a second asterisk, written informed consent. Now, in this particular rule, we'll see in some rules, written informed consent. That's not true in this one. Informed consent can be oral. However, look carefully at that definition. There are very specific elements of that informed consent, and everybody has talked about those generally. But as Kevin particularly has emphasized, informed consent means the client really understands what's going on and understands in his or her own terms. That means his or her own language, level of understanding. They understand the situation. They are making a completely informed decision. They know what the choices are, and they know what the implications are. All of those things are involved in informed consent. And so written informed consent is all of that stuff in writing. And so I would suggest, as a matter of practice, if you see the concept of informed consent in any rule, as a matter of practice, if you can get it in writing, that's best. Because it's your way of documenting that you went through that. Because the elements are very specific, and it's not something you want to leave to chance. There is a single express authorization for revealing a client confidence or secret, and that is for life-threatening criminal, potential life-threatening criminal, to prevent a life-threatening criminal act. So to prevent, and the rule says, and the statute says, may. You don't have to. You may reveal a client confidence or secret in order to prevent a life-threatening or serious personal injury criminal act. And that's quite specific. Before revealing information, that information to prevent a life-threatening criminal act, you must inform the client of the ability of decision and must attempt to persuade the client not to perform or to prevent him or herself that act. Now, just to show you the complexity of this one, as Kevin was mentioning, this is one where the Rules Revision Commission, the Second Rules Revision Commission, was very intent on taking everything out of the comments and putting it to the black letter rule. This is one where the comments survive. A lot of the comments do. There are 13 comments to this rule. And they present an excellent roadmap to how we got to this place. So it is very complex, and there's so much information here, particularly on this rule as on the others. Let it wash over you. If you take nothing else from this discussion, but client confidences and secrets are the holy of holies, you will be a long way toward understanding these. Then next one is Rule 1.8.2. And this is new. This is not something we have before. We have talked before about revealing a kind of confidence or secret. This is about the use of that information. So, for example, and this is one example that's come up in the past. Let's assume you're representing a second client, and you have information from representation from the first client. It could be used to the advantage of the second client and to the disadvantage of the first client. Now, you may not reveal that information. But you may be in a position to use that against the first client. This is specifically prohibited. It's a very short rule, but it addresses something that was implicit but not expressed in the prior rule. So it is going to be very important, to consider how you use information. I think the other thing that's introduced in these two rules, which is highlighted, something that you're going to see in all of the rules, is the introduction of a third party and the introduction of implications for a third party, and an introduction of how what you do impacts third parties and not just clients. So this is a very important rule, a very important aspect of who we are, and probably one of the more important distinctions of California law in professional responsibility and ethics and other states.
So now we'll move on to talking about confidential information of former clients. Teresa was addressing confidential information of current clients. Now let's move on to former client confidential information.
Okay, this rule is essentially identical to the American Bar Association's Model Rule of Professional Conduct 1.9c. We're just looking at paragraph C of Rule 1.9, duties owed to former clients. And one of the things you always remember, you probably remember from law school, or you've heard one of your mentors tell you, confidentiality duties don't die, they remain forever. You owe a duty of confidentiality to your client. But 1.9c1 carves out an interesting exception. Well, there's the usual one: the client can give informed consent to your use of the client's confidential information. But barring that, 1.9c1 provides that if the information has become, quote, generally known, close quote, you may use that information even without the client's consent. Now, what does generally known mean? It means widely available, widely known in the media. A lot of people have heard about it. It does not mean, and this is an important point to remember, it is in the public record. Because there is case law in California that says just because information is in the public record, it doesn't mean that the information is widely available or generally known. The point here is really lawyers are supposed to be risk adverse. So what you have to remember is risk adverse. It's probably a good idea to check with the client first and see if it's okay with the client, or simply not use the information. Of course, if it's a former client and there's generally known information about the former client, its corporate client, its plans, and you want to buy stock in that former client, there's no reason why you can't make that decision based on information that has become widely available. You're not using information that is otherwise protected under Rule 1.6 or Business and Professions Code 606AE. Now, the only point I want to make about paragraph C2, that talks about revealing information of a former client. Again, you can do it with the informed consent of the client, but there is no generally known exception. So you can't badmouth the former client, even if you have a particular grudge against that client. The client didn't pay your entire bill, or didn't pay your bill at all. You simply can't badmouth the client. You're going to run into trouble if you start to engage in that kind of conduct. It's something that you need to avoid at all costs. There is no generally known exception to revealing or disclosing confidential information of a former client.
And we'll move on to an example of one of the rules that now conflicts with the State Bar Act. And Teresa.
Okay. Now it's time to pique your interest. It's at that time of the morning, and this is sexual relations with a current client. Now, this is one of those things that conceptually is not all that complicated, but I do want to share with you this insight. It is never, ever a good idea to have sexual relations with a current client unless they're a spouse or a registered partner. That said, the prior rule allowed sexual relations with a current client, provided it did not cause harm to that client, generally speaking. And I did not completely appreciate the weaknesses of that rule until I wound up on a radio talk show trying to explain to the public why it's okay for lawyers to have sex with clients. So this particular rule now says there shall be no sexual relations with a current client. It's a prohibition, absent those certain exceptions, of course, in marital relations and domestic partners. They're to register. And it also, again, here is the inclusion of a third-party complaint. You could sometimes have a third party who is a complainant, perhaps in a disciplinary proceeding, or complainant in some other aspect where there's in some other context where there's a consensual relationship. And remember, we're talking about consenting adults. Remember, a coercive sexual relationship or a sexual relationship that is otherwise illegal. That's a different kind of problem. But this is specifically between consenting adults. So it's important for you, your reading. Another exception is that it is allowable if it predated, if the relationship itself predated the representation. All right. So the only advice that you can take from this particular rule and its changes is that if a lawyer is in a sexual relationship with a client, a current client, now, the lawyer has to make some decision about whether the client should have another lawyer or whether that relationship should be discontinued. There are no easy answers here. And frankly, there's a little bit of naivete in both the former and the current rule, and the rule that's about to become current. And that is that it's hard to regulate these kinds of relationships between consenting adults. However, there we are. And I commend it to your reading, and also to the fact that it can involve an organization. So if the sexual relationship is with somebody who is a principal or somebody who has a decision-making authority within an organization, it may also fall under this rule.
Thank you, Teresa. And what's interesting is that the State Bar Act still tracks our current rules, soon to be former. So there are certain circumstances, except for quid pro quo and that type of thing, where these types of relations are permitted. So it's possible that a lawyer could be subject to discipline even though their conduct is in compliance with the State Bar Act. So watch this space.
I think my microphone has run out of juice, so I'm going to borrow Eric's microphone. I just wanted to make one other point. I'm a big fan of viewing lawyers as risk-averse. I'm a very risk-averse person myself. I wouldn't think of going bungee jumping or any number of other things. But in terms of practicing law, I'm going to err on the side of caution almost every time. Although there is the legislation, you shouldn't think that legislation trumps the rule or vice versa. There is California case law that specifically states that the California Supreme Court is the primary authority for regulating the legal profession. I would go with the more strict rule in guiding my conduct in dealing with my clients, my current clients.
Okay, moving on.
Right, so whereas with 1.8.10, there should be no ambiguity as to who the client is. With 1.13, there may be. But keep in mind at all times that the client is the organization. So the organization, if it is your client, acts through a duly appointed constituent member. Typically the highest constituent member is the ultimate backstop. What you may find yourself in a circumstance with when representing a client is if the constituent, either your principal point of contact or some other member of the organization is involved in conduct that is adverse to the interests of the organization, you have a duty in that circumstance to report, and that involves a duty to report up, but not a duty to report out, keeping in mind that your conduct is governed as well by B&P Code 606081, the duty of confidentiality, and as has been discussed, that is broader than the attorney-client privilege. You're not in a position to go outside, with the exception, potentially, of the limited circumstance that is contemplated by 1.6. But again, because you are in a situation where the client is the organization can only act through individual constituents, and then as discussed, you would have a duty to report up if there is no action taken by the highest level decision maker within the organization. Then that could be a situation where you would need to act to disclose information outside, but that's the only exception. Otherwise, if you report up and there is no response, no action taken by the constituent, the highest constituent to whom you report, you may be in a circumstance where, because of the continuing duty of confidentiality, you are obligated to withdraw or resign. Again, if that is the remedy sought, you are obligated to report to the constituent member why you are withdrawing, why you are resigning. And that is part and parcel of the duties that you owe. Also worth noting that under subsection F, you're not permitted to mislead or deceive a constituent. So that would require, let's say, if you represent an employer and there is an employee, recipient witness, you need to make clear that you are not counsel for that employee unless there is informed consent by the parties represented and approval of that, as well as appropriate conflict waivers. And then we discuss, or we reference 1.13G, which is such a circumstance where you're representing both a client and a constituent. And that is all subject to rules 1.7, 1.8.2, 1.8.6, and 1.8.7, which deal with disclosures, what information may be made available, and so forth. So I would commend you to read that carefully if you represent organizations.
Okay, we're going to shift topics a little bit now. We're going to talk about fees and client property. And one thing, there's a lot of really new rules and exciting things that we need to talk about. I'm going to ask all the panelists to, so that we can get through our material as best we can, to really focus our discussions on what is different. We're going to assume that you know the basic rules about our existing rules of professional conduct. What we want to highlight here are what the differences are in the new rules, what you need to be aware of that maybe is not, not in the present rule. So we're going to talk about fees for legal services, fee splitting, and safekeeping of client funds. This is the client trust account rule. All of these three rules have some important changes in them that we'll need to pay attention to going forward. So the first, fees for legal services, 1.5. This again is the disciplinary rule with respect to fees, which means that it governs where a fee is unconscionable. That is the disciplinary standard for a fee. A lawyer is exposed to discipline if their fee is unconscionable. That's different than unreasonable. Unreasonable may subject you to different types of liability or may make it hard to collect your fee. But unconscionability is the disciplinary standard, and it remains the disciplinary standard. That has not changed. There are a few additional factors in the new rule to be considered when determining whether something is unconscionable, but for the most part, it's the same. What's particularly new in Rule 1.5 is that it specifically refers to earned on receipt or non-refundable retainers. That's something also sometimes referred to as a true retainer. It also specifically permits advance flat fees. So while these types of fee arrangements were things that maybe have been in practice, they were not specifically addressed in our disciplinary rule, and now they are. And when Eric will be addressing what you have to do with those types of fees and whether you can put them into your trust account or when you have to or when you don't. But for purposes of 1.5, it's just saying that this is a type of fee that a lawyer may permissibly charge. And again, the true retainer is one where it is not a retainer for legal services you actually provide. It is a non-refundable fee given for you just making yourself available for future employment. And that may be for a specified time or for a specified matter. And then a flat fee, of course, is just a flat fee, one price for whatever the legal services are that you will be providing, regardless of how much time it takes you to provide those services. And again, flat fees are permissible. What you do with them and the circumstances in which you have to put them into your trust account or not are subject to a different rule that Eric will be addressing.
I've got it there from two. Okay. Good. Thank you. All right, and this is of the rules in this section. This is probably the least dramatically different. I will commend you reading just the number of asterisks in this one. This is about splitting fees with other lawyers. No, I don't want to use it for sharing fees with other lawyers. And it's one of the first that acknowledges a lot of movement in trying to acknowledge the modern representation where there may be more than one law firm lending its specialty to a certain client matter. The asterisks have to do, for the most part, with consent, written consent, and all of those things are defined and very carefully. So to the extent that you have more than one lawyer or law firm representing a client, please be sure that all these boxes are checked because they're going to be very serious. Thank you.
And just one point on that, what's new on that rule is that fee splitting arrangements between lawyers now need to be in writing. That is not the case now. That's a new provision. And the other thing is they do have to be consented to by the client, but they have to be consented to by the client at the outset of the arrangement. The way it is now, the client just has to consent before the fee split. Now the client has to consent at the outset and the arrangement has to be in writing. So that's a pretty significant difference for people doing those types of fee arrangements.
All right, next we're going to cover advance fees, which are addressed in 1.15. One of the key takeaways is that the general rule is now advance fees must be held in trust. However, there are exceptions, and these are described in subparagraph B1, which provides, notwithstanding paragraph A flat fee paid in advance for legal services may be deposited in a lawyer's or law firm's operating account provided. And there's two requirements. The lawyer or law firm discloses to the client in writing that the client has a right under paragraph A to require that the flat fee be deposited in an identified trust account until the fee is earned, and two, that the client is entitled to a refund of any amount of the fee that has not been earned in the event the representation is terminated or the services for which the fee has been paid are not completed, and subsection 2 or B2, if the flat fee exceeds $1,000, the client's agreement to deposit the flat fee in the lawyer's operating account and the disclosures required by paragraph B1 are set forth in a writing signed by the client. So again, this is primarily concerned with a transparency issue, making clear that the notion that a flat fee is earned upon receipt is without any support, and one must adequately document, disclose, and educate the client as to how advance fees will be handled so as to remain compliant with the rules. Retained is the notion that there should be no commingling of attorney funds with trust funds, the exception being that if there are incidental expenses associated with maintaining the account, that's permitted. And then also, as indicated up on the slide, you must notify promptly when funds or other property are received. Again, this is a transparency issue to ensure that the client is kept apprised of developments affecting the fees that the client is paying.
Okay, we're going to move on to conflicts of interest. One more point on the fees, because it's part of the withdrawal. This is interesting. A lot of people, when their client's not paying, they may be tempted to or may permissively withdraw from the representation. The new withdrawal rule, which we won't be covering in detail later, so I'll just point it out now, 1.16B5 now requires that you're still permitted to withdraw if your client is not paying a fee, but you have to give them an opportunity to cure. So you have to give them a notice and time to cure their default on paying the fee or any other breach of the contract. But it's an important requirement that's not in our existing law. So before we leave fees, I just want to mention it.
And I'll just add one additional point regarding fees. It obviously behooves you to maintain records as to the work being performed. So in the circumstance where the representation terminates prior to its anticipated conclusion, if there is a dispute, you have records to support your fee claim in that circumstance. That's a bit more of a risk management issue.
Okay, so now on to conflicts of interest, where there have been some pretty significant changes. Let's take it away.
Okay, I'm going to start our discussion of conflicts of interest with what used to be called in the model rules, Rule 1.7, conflicts of interest basic rule, but it is the rule regarding conflicts involving current clients. And the primary, I guess you would say, the primary value that's at issue when you're dealing with the current client is the duty of loyalty. We as lawyers owe a duty of undivided loyalty to each and every one of our clients, meaning essentially that we cannot represent one client against another client. If we're in a law firm, another lawyer in our firm who is deemed to represent any clients we have cannot represent one of his or her clients against one of my clients. It's a law firm client. You simply would be violating the duty of loyalty. Of course, as California has always provided, there is the ability to obtain the client's informed written consent that would permit the conflicted representation. My view on that is good luck in getting the client's informed written consent to have you, his or her lawyer or its lawyer, represent an opposing party against them. I don't think it's going to happen all that often. Not after the fact. You might be able to obtain, under appropriate circumstances, an advance consent from a particular client, but I'm not sure that a client presented with an ongoing conflict would be that willing to consent. Okay, let's take a look at 1.7. Let's see how it's structured. Previously, we had one conflicts rule. It was one major conflicts rule. It was Rule 3-310. Paragraph A included definitions. Paragraph B involved what might be called conflicts that would have an adverse effect on the lawyer's ability to exercise independent judgment on behalf of the client. Paragraph C, which dealt with current clients' conflicts, both actual and potential conflicts of involving current clients. Paragraph D, aggregate settlements, that's been moved to a standalone rule 1.8.7. Paragraph E, which is really duties owed, although it mentions both current and former clients, it's primarily addressed to former client conflicts, which Teresa will be talking about when she discusses Rule 1.9, new Rule 1.9. And then finally, paragraph F of former Rule 3-310, which addressed third-party payments and the conflicts that might arise there. The person who pays often wants to know about the case, but you have a duty of confidentiality, the person you're actually representing, and you simply can't do it. That becomes Rule 1.8.6. We're not going to discuss those rules. We're going to focus on the main rules, 1.7, 1.9, and 1.10 and 1.18. Okay, so the structure of 1.7, paragraph A. This is direct adversity. You can't represent one client who has interests adverse to another client. Direct adversity, this implicates the duty of loyalty. Paragraph B is all about the duty to exercise independent judgment on behalf of each and every client. In other words, you might have your own personal interests. It might be, you might have a relationship with someone who has an interest that's going to be substantially affected by your representation of a client. And the question here really is this something that are these relationships or interests that you might have something that rises to the level that it might impair your ability to exercise independent judgment? In other words, there's nothing else going through your mind. What's going through your mind, I've taken this client, I'm advocating on behalf of the client. At this point, can I advocate without any extraneous considerations? And if you believe that these extraneous considerations might have an impact, in other words, might significantly impact your ability to represent the client. In other words, there's a significant risk that there will be a material limitation on your ability to represent the client, to provide that independent judgment on your client's behalf in assisting your client to make decisions. Then it's a conflict. What happens if there's a conflict? What happens if there's direct adversity? Well, you can obtain the client's informed written consent. Under paragraph B, it's probably going to be more likely to obtain the client's informed written consent where there isn't direct adversity. But there is this potential of significant risk that there is going to be a material limitation on your ability to represent the client effectively. So you can obtain the client's informed consent. However, there's something else you have to do in the paragraphs A and B. You must comply with paragraph D. And what is paragraph D? Paragraph D involves what we have referred to in the literature and the case law as unwaivable conflicts. There are certain situations that even if the client is willing to give his or her informed consent, it doesn't matter, because it's a situation where, because of policy reasons, it's believed that the lawyer should not be involved in the representation, in the dual representation. One, as Eric mentioned early on, competence is unwaivable. So a client can't consent to you providing incompetent representation prospectively. So if you reasonably believe you're not going to be able to provide competent representation, then you have an unwaivable conflict. If the representation is one that's prohibited by law, well, you can't get the client to consent to you and the client going ahead and violating the law. I mean, the client's consent is immaterial at that point. Finally, and this should be pretty apparent to folks, you can't represent in a proceeding before a tribunal both parties where their interests are adverse. They have claims against one another. You simply can't do it. That makes perfect sense. So even if the client would be willing, under the circumstances, to consent, here the rule is telling you it doesn't matter. Now, is this new? Yes, it's new in a disciplinary rule in the text, but that was already in a comment or a discussion paragraph in Rule 3310. Where was it else? Well, what was that discussion paragraph? It was simply citing to the case law. Again, when you're dealing with conflicts of interest, don't rely simply on the rule. Look to the case law. And the comments to this rule provide you with a number of references that will provide you with a good overview of the case law in this particular area. Now, paragraph C is interesting in and of itself. It's paragraph C is a carryover of two rules from old paragraph rule 3-310, B as in boy, subparagraph 1. That's C1, And then you have former Rule 3-320, which deals with the obligation of a lawyer to disclose relationships, personal relationships that, or professional relationships that a lawyer might have with the lawyer on the other side, the lawyer representing the adverse party. Here, what should you do? It's saying it might not rise to the level where it is a significant risk that your representation will be materially limited, but still, you might be required to at least disclose to the client the existence of this relationship or this interest, this extraneous relationship or interest. Now, my rule of thumb on this, it's not in the rule, it's not in the comment. If you think that after the fact, as you're going through it, ask yourself, when the client finds out about this relationship, after the fact that this has existed and I've been representing the client, would the client be really pissed with me for not having disclosed it? I mean, that's sort of the, it's not a legal term of art in any respect. But you have to ask, would the client be upset? Ask yourself, would I want to know about this relationship? And if your answer is yes, disclose it to the client. Now, let me give you a caveat. What do you have to disclose? And here's something that is arguably an oversight in the new rules. In the former rules, Rule 3-310A sub 1 defined disclosure. And disclosure was informing your client of the actual and reasonably foreseeable adverse consequences of the conflicted representation. Well, there is no definition of disclosure, either in Rule 1.7 or in Rule 1.0.1. But if you look at Rule 1.0.1, paragraph E, that is the definition of informed consent. It is virtually identical. It's nearly identical to old 3-310A sub 1. Instead of using the word disclose to the client, or inform the client of the reasonably foreseeable, what the rule requires is that you must communicate and explain the actual and reasonably foreseeable adverse consequences of a particular course of action. Specifically in a conflict situation, that would be the conflicted representation. So what I'm going to tell you, and this will probably be litigated at some point in the future, is where you see the rule saying disclose, go to Rule 1.0.1 sub E, paragraph E, and look for those words, communicate and explain. I think they mean the same thing.
Thank you. We're going to go through this very quickly. This is 1.9A and B. Now, in this particular... Hello? Can you hear me? All right, good. This will work. All right. This one anticipates two things. Number one, if you remain in the firm and you are representing a second client, you represent one client, you're representing a second client in the same matter or is substantially the same matter or substantially related matter, and it's adverse to that first client, then you require the written informed consent. Subsection B anticipates the movement. You're no longer in the same firm, but again, you have something that you're representing an adverse client, which is who is in the same matter or substantially the same matter. This is something that a lot of attorneys will find themselves in. It requires the informed written consent, and it also, you have to, in comments, watch for this. There is a difference between just publicly available information and generally known information. Just because something is publicly available doesn't mean it's something that you can reveal or talk about. But the real difference in subsection B, or the real test, litmus test in subsection B, as to whether you can reveal this information. Were you in a position in the first firm representing the first client to acquire information that you can use adversely to the second client?
We'll cover business transactions with clients as well. This is in the present 3-300, and the new rule on this is 1.8.1. The rules are very similar. They are both triggered when you enter into a business transaction with a client, or you acquire pecuniary or security interests adverse to your client. So both rules are triggered in the same circumstances. But the new rule is a little more stringent. So in the current rule 3-300, when you're going to enter into a business transaction with a client, the terms have to be fair and reasonable to the client, and the terms have to be disclosed. The client then has to consent to the terms, and you have to advise in writing that the client may seek advice of an independent lawyer. So arguably, number one, you're saying you may seek, and that disclosure probably has to be made even if the client in fact is represented by a lawyer with respect to the transaction. You still have to give the disclosure under the present rules. Under the new rule, number one, if the client is represented with respect to the transaction, you don't have to give that written advice that they have the right to seek independent counsel. Seems obvious. If they have a lawyer, they know that they have the right to one. And also the language is that you have to give the client notice to seek the advice of an independent lawyer and give them time to do so. Note, the present rule, all you have to do is say that you may seek the advice. So it's a little bit more of a direction to seek the advice of an independent lawyer. And very importantly, the client now has to give informed written consent to this transaction. Now, it's not just the disclosure and then the client consents. You have to give informed written consent, which is a defined term, as Kevin has discussed. We just looked at it, and so it's a lot. You've got to inform them all the facts necessary so that they can make a decision as to how the consequences of this transaction will impact them. So informed written consent is an important requirement that is not present in the current rule on this topic.
All right, and then we'll go ahead and jump into 1.10, the imputation rule. With regard to that, it recognizes both the need for transparency as well as the inherently changing nature of our practice with the mobility of lawyers. Provides that if the lawyers within a firm, any one lawyer within a firm, would be proscribed from the representation if that lawyer were in practice, then it's not permitted, subject to certain exceptions. First exception is not all that significant. Prohibition is based on a personal interest of the prohibited lawyer. That seems self-evident. But the second one is the one that most often is likely to come into play. That prohibition is based upon Rule 1.9a or b and arises out of the prohibited lawyers association with a prior firm. And these are the key categories. The prohibited lawyer did not substantially participate, is timely screened, and there is disclosure to the client promptly in written form so that the affected former client is so that the affected former client is sufficiently enabled to ascertain compliance with the provisions of the rule, which shall include a description of the screening, the procedures employed, and an agreement by the firm to respond promptly to any written inquiries or objections by the former client about the screening procedure. So you have to disclose that promptly and make sure that there is adequate consent, written consent obtained by or from the former client. It does provide for waiver under 1.7 and does impose a duty consistent with BNP Code 6081 and Rules 1.6 if material. So important in the context of the increasing frequency with which lawyers move firms. You need to refer to this rule, make sure you are fully compliant, make sure that the former client is fully apprised and signs off in writing.
Thanks, Sarah. Should we take a break? Why don't we take a break and we'll pick up right after. So thanks. That rule in particular is a huge new rule for California. We never had an express screening rule before. So anyone that's in that kind of environment certainly mandatory reading on that.
And if I just might want to add something, that the whole purpose of a screen is to isolate a lawyer from disclosing confidential information to other lawyers in the firm, or having those lawyers disclose confidential information to the isolated lawyer, the lawyer being screened. It is there to protect against the presumption of shared confidences within a law firm. It doesn't apply if the lawyer who has moved into the firm, the lawyer who's going to be screened, who's going to be isolated, doesn't actually possess the confidential information. So when you were in your former law firm, say law firm A, and all the information of every lawyer in that law firm is imputed to you. You are presumed to know all that information because you're talking to every lawyer in your 2,500 lawyer firm, even if they're in some other city 5,000 miles away. We assume you talk to them about all of their cases. Okay. Let's have stereo. The thing is, once you leave your old firm where you've only had computed knowledge, you no longer have that knowledge. It's like you acquired dandruff at the old firm, and now when you leave that firm, you walk through the door, and there's a bug zapper that blows the dandruff off you. You're no longer a tainted lawyer. You no longer have to be screened. On the other hand, if you actually worked on a matter, or as Teresa was explaining, 1.9b, you acquired information. You didn't work on the matter, but maybe at the water cooler or at the coffee machine, you heard lawyers talking about a case. A lawyer walked into your office and said, I have this problem with the client. Let me talk with you about it. You've acquired the information. That's like having a tattoo. That doesn't leave you. You carry the tattoo with you into the new firm. That's where you need the screening.
Say goodbye. 11:15. Thank you.
going to cover the last rule in our series on conflicts of interest rules. And it deals with duties that are owed to a prospective client. This is a new rule in California. We've had the same issues addressed in case law and in ethics opinions by the state bar and local bar associations, which pretty much come down the same way. So again, you really need to look at the case law, look at ethics opinions that can flesh out the rule for you. But essentially what goes on, the way the rule is set up, paragraph A defines what is meant by a prospective client. And a prospective client isn't just anyone who walks through your door. It is a person who comes to you, consults with the lawyer, actually sits down, has a consultation with the purpose of either retaining the lawyer or to secure legal advice. Those of you who are familiar with our evidence code and the definition of client in evidence code will realize that this definition in paragraph A pretty much parallels the definition of client in the evidence code for the attorney-client privilege. It's actually in section 951. The rule then goes on to state, just as the evidence code does with respect to the attorney-client privilege, and remember, as Teresa mentioned before, duty of confidentiality and attorney-client privilege are not coterminous. What you have to remember about that is that its duty of confidentiality is much broader. Here, it now sets up that, just like in the evidence code, even if there is no retention, or the client doesn't retain the lawyer, prospective client doesn't retain the lawyer, under the evidence code, the privilege still attaches. Well, now you're being told that even if the client doesn't retain you, you still owe that prospective client the duty of confidentiality. Now, what happens to the lawyer who actually had the consultation with the prospective client? The lawyer is a solo practitioner. That lawyer is going to be precluded from representing the any opposing party, or in any matter in which the information the lawyer has culled from the consultation is material. So in any matter where another party is material adverse to the interests of the prospective client, the lawyer is going to be precluded. Okay, that's fine. The lawyer is prohibited from representing your solo practice. You're out of the game. But how about a law firm? Are all other lawyers in your law firm precluded? Well, you can always obtain the prospective client's informed written consent to allowing the law firm to be represented and the consulting lawyer being screened. Or, paragraph D tells you, just as you can proceed under Rule 1.10, you can be screened a non-consented screen. In other words, you can erect a screen, isolate the lawyer even without the consent of the prospective client. And here's the rub. There is no provision that says the lawyer did not substantially participate. It doesn't make much sense to have such a provision. Rule 1.10 limits the screen lawyer to lawyers who did not substantially participate in the prior representation. Here, well, if you consulted with the client, there could be a wide range of information that could have been provided, going all the way from you got the client's name, the name of the opposing party, and whatever other information you needed to run a conflicts check. That's all you got. But here it's saying, even if you got more information, you got information that you needed in order to determine whether the client had a viable lawsuit. So you may have learned highly sensitive and received highly sensitive information from the client. Still, that lawyer can be screened so long as the lawyer only acquired information the lawyer needed in order to make a determination whether to represent the client or whether the lawyer was capable of representing the client. Sometimes you need at least information to know whether there's a conflict, or information as to whether it would be a viable lawsuit so that you wouldn't be filing a frivolous motion. Sometimes you need to get enough information. So as long as the consulting lawyer took pains not to get more information than was necessary to make those determinations, that lawyer can be screened under paragraph D. But remember, in some instances, it doesn't take much. A client can disclose wholly damning information in 30 seconds. So it's not going to be how long the consultation was. It's really going to be what was the substance of the consultation.
Okay, so we're going to move on to rules governing the lawyer's role as advocate. And we have a few here. One governing the delay of litigation, which is new for us in California. Candor toward the tribunal, which we do have, but there are some important differences in the new rule. Fairness to opposing party and counsel, which is a very interesting rule that is somewhat existent in what we have today, but is more expansive. And then two other rules here, lawyer as witness and advocate in non-adjudicative proceedings. Those last two we won't cover in depth. There's a slide on them. The most important thing about lawyer as witness is that it now also applies in non-jury trials as well. The present rule only applies in the context of a jury trial, whereas a witness before a jury now it applies outside of that. But again, we won't, those last two we won't be covering extensively. The first, delay of litigation is Rule 3.2. We have no current counterpart. This is a very short rule, it's one sentence. And it basically says that a lawyer cannot use any means whose, quote, substantial, and this is a defined term, substantial, purpose is to delay the proceeding, prolong the proceeding, or cause needless expense. What is substantial in this context is defined, and substantial basically has to do with materiality. And so the question is, or something of, let me see, materiality or clear and weighty importance. That's how substantial is defined in 1.0.1. And so this is the kind of thing that we don't have a lot of guidance on at this point because it's a new rule. But again, this is, and it also dovetails with some other obligations like the duty of diligence. So we see this here again in this rule. We've got 1.3, which is new. You've got to be diligent in your representation, and now we've got a rule that says you can't do things whose substantial purpose is just to delay the litigation. Business and Professions Code 6128B also has in it a prohibition on willfully delaying a client's suit. So again, these are things that have been the subject of discipline for years because lawyers sometimes abandon their clients or don't pay attention to their matters and let them go into default, that type of thing. This is just another sort of rule in the potential arsenal of things that you could run afoul of if you do that. So here, delaying litigation for no purpose other than to cause everybody a lot of expense is prohibited, and I suspect we'll be seeing a lot of this rule cited in meet and confer letters going down the road in the future.
All right, now we're going to talk about Rule 3.3, and that is candor toward the tribunal. Now, this is former Rule 5-200, and frankly, we've gotten so used to this, it's so natural to us, that we haven't questioned it much anymore. Of course, we don't offer false evidence to the court. Of course, we don't offer authority or cite authority that is not applicable, false authority. And of course, we don't offer any evidence that we know to be false. But there is a change in Rule 3.3. And this is a requirement to take affirmative action when it happens anyway. And when would it happen anyway? Okay, perhaps you have called a witness and you know, and you learn after the fact that the witness has testified falsely. Or you are prepared to offer a piece of evidence and you learn that it is in fact manufactured evidence. So you have to take some sort of remedial action. Well, what form can that take? A lot of reasonable minds in the community differ. This is one rule that still has a lot of controversy surrounding it. So, for example, if I'm a lawyer, I'm a captain of the ship, I have presented evidence that I later learned was false, I have the opportunity, not only the opportunity, perhaps the obligation, to withdraw that evidence or to ask the finder of fact to disregard it. However, even if I haven't revealed confidential information from the client, that might reflect poorly on the client, or that might compromise the client's case or undermine the client's case. And there is a very reasonable school of thought that would say that that is revealing a secret of a client. So there's tension in this area. There's tension between the candor that is anticipated under this rule, the level of candor required from a lawyer under this rule, and client confidences or secrets. Client confidence or secrets remain sacrosanct. However, there might be a tension between obeying the four corners of this rule and having some negative implications or negative impact on the client. So you should be aware of that one.
I just wanted to add one thing, and as far as how long does your duty to take remedial measures last? I just wanted to add this because an important point to make is that when this rule went from the Commission up to the Supreme Court, the rule, paragraph C, said the duration ran until the termination of the proceeding or the withdrawal of the lawyer, whichever comes first. Now, realistically, what that's saying is, well, the lawyer is faced with, well, I can either go through the remedial measures or simply withdraw. And the point was that we really wanted the lawyer to engage in remedial measures, but other folks said, well, once I'm away from it or the client discharges me, I shouldn't have to be responsible for the taking remedial measures. Well, the Supreme Court saw that, and it didn't like that. It struck the part where it says where the representation is terminated. That means either withdrawal or the client discharges you. The Supreme Court wanted the duty to continue until the conclusion of the proceeding, and that's explained in the comment 6, which says that's either a final judgment in the proceeding that has been affirmed on appeal or the time for review has passed. It's an important point to remember. If you're withdrawn, you're not out of the suit. I mean, you have to take those remedial measures before you withdraw, so you at least have to go through that process, try and convince the client to rectify the matter.
All right, the next rule we're going to cover is 3.4. This is a combination of two prior rules. There's 7 categories of obligation that are imposed by this particular rule. It essentially deals with the handling of evidence and witnesses. In particular, I'd point to comment 1. There's 2 comments for this particular rule, but one focuses or specifically calls out the obligation to not impede or obstruct unlawfully another party's access to information, and in the comment references electronically stored information. I would suggest the drafters had in mind when preparing this rule the duty of competence as well under 1.1 and being fully apprised or adequately apprised as to, for example, your client's retention policies, and ensuring that with electronically stored information that you take adequate steps at the outset to put in place an appropriate litigation hold so that the client isn't automatically destroying information as part of its routine and thereby creating a potential spoliation issue for the client and for you, potential violation of 3.4a. B deals with suppression of evidence. C deals with falsifying evidence or testimony and extends the obligation to not counseling others to act on your behalf. That's a critical thing to keep in mind. Just anecdotally speaking, I was communicating with a lawyer I represent who is a defendant in an action, and he was interested in communicating with co-defendant without the benefit of the lawyers being involved. And I suggested that he couldn't take his lawyer hat off at the time he became a defendant, and he would be well served by going through counsel rather than trying to approach another party directly. All right, let's turn to 3.4D. That deals with compensation that is permissible or not. It does include exceptions for paying witness expenses, reasonable expenses for compensating witnesses for lost time or other expenses they incur, and obviously there is going to be an exception for paying professional witness fees. Can't counsel your client to disappear or a witness to disappear so as to make him or herself unavailable. And at trial there is, and this is limited per the black letter of the rule, it's limited to asserting personal knowledge of facts in issue. So distinguish that between a declaration that counsel might submit in support of a motion prior to trial. Here, the drafters saw fit, and the Supreme Court saw fit, to preclude a lawyer from asserting personal knowledge of facts, but limited it to trial or, in a criminal proceeding, stating a personal opinion as to the guilt or innocence of an accused.
Okay, so there are two more slides in there for some rules that I mentioned earlier, but we're going to move a little bit faster. The next group of rules that we'd like to talk about are ones that govern transactions with persons other than clients. And this is an interesting area where we have some new rules that we never had before. One relates to truthfulness in statements to others. There's no current rule counterpart for that one. Communication with a represented person, we obviously have that already in 2-100, but this one's a little bit more robust. Communicating with an unrepresented person, this is something that we don't have in our present rules. And duties concerning inadvertently transmitted writings, also a new rule, although I will say not a new law. So again, this sort of dovetails on some of the comments Kevin had earlier. A lot of what is here and what we're going to go over, particularly in this section, are not new laws. They're not new duties, but they are now found in the disciplinary rules, which makes them lawyers subject to discipline for violating them, as opposed to other potential types of liability when they're not in the rule. Truthfulness in statements to others, this is Rule 4.1. Sometimes referred to as the negotiation ethics rule. So what can you say to opposing counsel or to any other party in a litigation? Do you have any duties to them to tell the truth? And this rule makes clear that you cannot make a false statement of material fact or law. There's not much new there. We already know that we can't defraud people, and that's no special rule just because you're a lawyer in the context of a lawsuit. You already can't defraud people, and that is the same, but it's now embodied in this rule. But what about a duty to disclose? What do you have a duty to disclose, if anything, to another party in a lawsuit? And here, or not just a lawsuit, in any context of representation. And there, you can't fail, this new rule provides that you can't fail to disclose a material fact when necessary to avoid assisting a criminal or fraudulent act by the client. But a huge caveat to this obligation is your duty of confidentiality to your client. So I wonder how many times you might actually find yourself in a position where you're going to be disclosing something to the other side that's material to prevent, assisting in a criminal or fraudulent act that's not confidential information. So usually you would have knowledge of something like that as part of the context of your representation of a client, and that would make it confidential. So unless you have the client's consent to go ahead and tell the other side whatever it is you think you need to say in order to prevent your client from or avoid your client committing a fraudulent act, If you can get the consent, great, but I don't find it very likely that you will. However, if you can get the consent, or if you can make a disclosure that will avoid assisting in a fraudulent or criminal act that is not a confidential piece of information, then you do have now an affirmative duty to disclose that. And one interesting aspect of this Rule 4.1, it's not in the rule, but now that this tracks, this rule is here and it tracks the ABA model rule, it may be that some of the ABA model, the ABA opinions interpreting this rule may start to sort of seep in to our analysis of what the obligations are. And again, at the outset, Kevin mentioned that our rules are not the model rules. In many, many circumstances, our rules, although the numbering is now the same or similar, the rules themselves are not the same. But sometimes the rules are very, very similar to the model rule. And this is one that's very similar to the model rule. And so you may be looking at ABA opinions on these rules to see how they're interpreted for further guidance. And one of those opinions talks about the potential for an implicit representation being one that violates Rule 4.1. And by implicit, the example they give, at least in the opinion, but it makes me think a little bit, but settling a lawsuit, for example, in a personal injury case where your client is deceased, but you don't disclose that the client is deceased. And so there's this implicit representation, if you're settling a case on behalf of a client, that the client is alive. And so that could be something that by not disclosing it, it's not so much as a concealment as it is an implicit representation that some certain set of circumstances exists, and you not making it clear that that's not the case can violate this rule. So I think that's an interesting potential out there.
Okay, next we're going to talk about communication with a represented person. Now this used to be, it was formerly Rule 2-100, and it was framed as communication with a represented party. And this was, and actually the law isn't changing that much, but the rule was not specific about the difference between a party and a person, and now it is. And here's the difference. You can have a represented person in the middle of something that is litigation or potential litigation, and that's not necessary, and that person hasn't ripened into a party. This rule is now addressing a represented person, which could also be a represented corporation or an organization. Former Rule 2-100 talked about a represented party, and then it went on to discuss in the comments how a represented person is also is considered by this rule. Now it's expressly in there. And no communication without the consent of the attorney, the other attorney, not the represented person. So under this new rule in the comments, you will see that even if the represented person initiates the contact, the attorney is supposed to immediately stop that communication and to seek consent or advise the opposing counsel. Of course, the other exceptions to this rule still apply. Communications with a public official, communications authorized by law, and communications authorized by court order. So just a clarification, an important one, nothing that we'll find particularly different in practice, but it is something that is much better, gives us much better guidance.
All right, the next rule we're going to cover is 4.3, another that deals with the issue of transparency. This is concerned with communicating with unrepresented persons, essentially obligates the attorney to make clear that if representing a client, that the attorney is not disinterested. If the lawyer knows or reasonably should know or believes that the witness or third party believes the lawyer is disinterested, there is a duty to correct that misapprehension. As I mentioned, this is an entirely new set of obligations for us. When the interests of the unrepresented person conflict with that of the client, the only advice which the lawyer may give is to recommend the unrepresented person seek legal counsel. And there's a duty to not seek or obtain privileged or confidential information by any improper means. So this is covered in subsection B. Lawyers shall not seek to obtain privileged or other confidential information the lawyer knows or reasonably should know the person may not reveal without violating a duty to another, or which the lawyer is not otherwise entitled to receive.
One thing I think that's interesting about that last point, you know, the lawyer can't attempt to get privileged information that the lawyer is otherwise not entitled to receive, right? So the only way the lawyer could be entitled to receive it in most circumstances would be if the attorney-client privilege is being waived. So it does seem to me that under this rule, you could still ask the client, you know, I mean, an unrepresented person you're talking to, like a witness, you know, do you want to waive or are you waiving the attorney-client privilege? And if they say yes, then you could go forward. It's not necessarily an absolute prohibition that you can't ask for attorney-client privilege communications. You just have to make sure that you're entitled to receive them before.
I just wanted to add that what's also was going through the minds of the drafters with this is if, for example, the witness is a former employee of an organization, the employee is in no position to waive the attorney-client privilege because that's the owner of the attorney-client privilege is the organization itself. So if it's an individual witness who is not associated with an organization, fine, waive is a possibility, but if it is a former employee of an organization, the organization is the only person, and our definition of person in the Rule 1.0.1 includes organizations. Only the organization is permitted to waive the privilege. The other thing it would apply to, and this went through the discussions of the commission, is not just privileged information, but also information that the person is by law or contractual obligation prohibited from disclosing. For example, trade secrets, like if they have a non-disclosure agreement.
So you can't ask for the formula to code, basically.
Oh, darn. Okay, Rule 4.4. Again, as Suzanne mentioned at the outset of this group of rules, this is just an example of the codification of case law. All that the drafters did was, in drafting this particular rule, is to take the rule as it exists in a number of cases, including the RICO against Mitsubishi, California Supreme Court case, McDermott, Will, and Emery, a recent case with which one of our panelists is quite familiar. The state compensation case, state compensation, also known, it's abbreviated, generally referred to as the state fund case, or the state fund rule, and the case Clark against Superior Court. These are all cases, I believe they are, most of them are cited in the comments to the rule. But essentially what happens if you obtain inadvertently disclosed documents? Your first reaction is to say, whoa, Christmas has come early this year. But that's not the appropriate response. The appropriate response is to notify the other side that you have this information. And important points to understand, under this, you really can't read this rule without looking at the case law, because it doesn't matter whether it's stamped attorney-client privilege or attorney work product or confidential. If it is apparent from the document itself that this is information, it's attorney work product or it's privileged information, if the entire strategy of the other side is laid out on a napkin, that's protected information. You have to disclose that information, that the fact, and notify the other side that you have it. Now the other side will probably say, send it back, don't make a copy, send it back. You are then supposed to agree, reach an agreement with the other side as to what to do with the material. If you can't reach an agreement with the other side, here's the important thing. Remember these three words, not your call. It's not your decision. You say, well, this is a crime fraud exception. I can use this material. No. It's not your call. You have to go to court to get the court's determination as to what to do with it. And guess what will happen to you if you decide you're going to make the call and you're wrong? You're going to be disqualified from representing the client, because the court is going to be in the position where it's trying to protect the integrity of the proceeding before it. And if one side has the other side's strategy, you can't really have a proceeding that is going to go according to our concept of integrity. The court will end up disqualifying
So the next group of rules that we'd like to discuss are those related to law firms and associations. And we have some new rules in this group as well. Actually, these are all new rules because they all deal with supervisory obligations. And so we'll talk, just jump right in here. So Rule 5.1 is now a rule that governs the responsibilities of managerial and supervisory lawyers. And in our existing rules, at least for the next 5 days, the only place where we find a duty to supervise that's articulated is in a comment to the rule of competence. And so you're talking about competent, or the duty to provide competent representation, and then in a comment to that rule is, oh, and by the way, you know, the duty of competence includes the duty to supervise, and that's pretty much it. Well, now we have 3 rules that talk about this, and they're much more fulsome, and they have a lot more to them than just what was in the prior comment. Managerial lawyers in a firm have to take reasonable efforts to ensure that there are measures in effect that will give reasonable assurance that the firm and the lawyers within it are complying with the State Bar Act and the rules of professional conduct. There's a lot of reasonableness and reasonable in that sentence and in the requirements, and the overall purpose for that is to get lawyers thinking about this, get supervising lawyers thinking about this. They have more than just their own garage to keep clean. If they're running a firm, if they have supervisory authority, they need to think about, is the firm on a whole? What are they doing? What are my non-lawyer employees doing? Are they out there, you know, carrying around confidential information on their computers? Are they, you know, what am I telling lawyers they can and can't do about email on their phone? Am I putting in place things that will protect my client's confidential information? Those types of things basically requires supervisory lawyers to go outside of themselves and to look at what every lawyer in the firm is doing and what procedures are in place in the firm to take reasonable steps, to have reasonable assurance that you're not violating any of the rules or any of your duties to clients. It goes beyond competence. You know, the most, the number one thing that supervisory lawyers do is tell or advise in the context of the representation what a junior lawyer should or shouldn't do. You're not always focused on, oh, and what about the duty of confidentiality, and what about these other duties that aren't related to directly necessarily to providing legal services. So the lawyers who are supervisors also may be liable themselves for their subordinates' violation of the rules of professional conduct or State Bar Act if they order the subordinate to engage in the violation, or they know and ratify the violation by the subordinate, or they knew of the conduct when it could still be corrected and they did not take remedial steps. So under those circumstances, a managerial or supervisory lawyer can be liable themselves for someone else's violation of the rules. And another important aspect of the rule with respect to supervisory authority, you can have supervisory authority over lawyers in your firm or paralegals in your firm, or lawyers that are not employed by your firm at all. Co-counsel, for example. If you're in a supervisory relationship with co-counsel, you can also, you're still responsible for what they're doing in the same way that you would be for subordinates in your firm.
I just wanted to add a couple of things, and it came across in what Suzanne said. This rule does not impose vicarious liability. You're not going to be disciplined for the underlying act. A good example is a case out of New York where a brother never trusted family member to run your trust account. The brother embezzled $4.5 million from the lawyer's trust account. Used it, among other things, to go to Atlantic City, to gamble, but also, ironically, to pay his son's tuition to New York University Law School. But that's neither here nor there. What the lawyer was disciplined for was not the act of embezzlement itself. That there was no vicarious liability. The court took pains to recognize that the lawyer was disciplined for the lawyer's failure to supervise. It was the failure to supervise was the act that was disciplined, not the lawyer's, you're not imposed liability for the acts of the subordinate who is acting.
That is a good point. And again, the biggest difference there with respect to how far your responsibility goes does depend on your position in the firm. So managing lawyers have the responsibility to make sure that the firm overall is complying with the rules. And then supervisory lawyers, so that can be even a senior associate or someone else, has the other obligations we talked about that supervisors have to make sure that, to take reasonable efforts to ensure that their supervised lawyers don't violate the rules. And then Rule 5.2 is basic, 5.3, I'm sorry, is basically the same set of responsibilities for managing lawyers and supervisory lawyers, but it runs to non-lawyer employees, and that can be in-house, outside contractors, any non-lawyer. The same supervisory roles and managerial roles have to be fulfilled.
Thank you. And I wanted to, I haven't had occasion a couple of weeks ago to talk to a large group of paralegals, and they were very interested in this rule. And one of the questions, they said, can I take this rule and walk it down the hall to my lawyer? They wanted to, a lot of times, a lot of the particularly client trust account things, conflicts issues, a lot of those are entrusted to employees and the paralegals, and they know what they're doing. But if they're asked to do something of which they question, and they want to be able to walk this rule down the hall, and to remind the lawyer that the lawyer will be responsible if they are directed to do something that's inconsistent with the rules. So they were pretty tickled with this rule. So the responsibilities is 5.2. This is a new rule, and again, it's not new law, just a new rule. And that is every lawyer, including a subordinate lawyer, is responsible for his or her own compliance with the rules. And even if a superior lawyer instructs that lawyer to do something that the subordinate lawyer believes is inconsistent with his or her professional responsibility, that lawyer must decline. That said, they can arrive at a reasonable resolution that would resolve both of their concerns. And if the duty of professional responsibility is questionable, in other words, it's unresolved, they may find a resolution or may take action and test it. But this is not a Nuremberg defense, and I have to thank Kevin for that particular phrase, because that's exactly right. The devil made you do it will not go in this. Each lawyer coming right out of being sworn is going to be responsible for compliance with this full body of law.
And just to quickly add something, I've surveyed a number of cases from other jurisdictions. There haven't been a lot of cases where a lawyer has been disciplined under this rule. But wherever a lawyer has been disciplined, a subordinate lawyer, it's because it was a no-brainer that you couldn't engage in the conduct that the supervisor directed you to engage in. And I'll just give you one example. Is a case out of Arizona from 1990, In re Ocrassa, Ockrassa, where a lawyer came on and was working in the prosecutor's office. Prosecutor said no problem in prosecuting the defendant. It turned out the defendant had been represented by that very lawyer in a previous lawsuit, and the court just noted, listen, it would have taken minimal research, like open up your rule book to Rule 1.9, and you would have known that you couldn't have done this. So you can't say that it was a reasonable resolution of an arguable question of professional responsibility. It was not. This was a blatant violation of the rules, and therefore you will be disciplined.
Okay, so now we're going to move on to rules governing the lawyer's relationship with the public at large, the advertising type rules, and providing information about legal services.
All right, the first of these we're going to cover is 7.1. This is formally 1-400. It largely carries over in many respects, deals with false and misleading statements, and specifically prohibits false or misleading communications, which it defines as a statement that contains a material misrepresentation of fact or law, or omits a fact necessary to make the communication considered as a whole not materially misleading. So this statute, or I'm sorry, this rule specifically is intended to deal with, again, the transparency issue, ensuring that what representations are made to the public are factually accurate, and imposes duty to correct and avoid at the outset. 7.1 specifically does provide for the promulgation of standards and talks a bit about what is specifically prohibited in the comments. Not surprisingly, we still have the carryover that any communication that includes an express guarantee or warranty as to a result of a particular representation is on its face false and misleading. Deals with the issue of when truthful statements may be misleading if they omit a fact necessary to make the communication considered as a whole not materially misleading. And also provides that a truthful statement is misleading if presented in a manner that creates a substantial likelihood that it will lead a reasonable person to formulate a specific conclusion about the lawyer or the lawyer's services for which there's no reasonable factual foundation. You'll see the consistent thread throughout this rule, which again is largely a carryover, is that the concern is with the public perception of our profession and ensuring that representations that are presented in the form of marketing or advertising material is consistent with these rules and consistent with factual representations being made. Subsection or comment 4 deals with the disclaimer that past results are not representative of future outcomes. That largely carries over. And section 5 or comment 5 prohibits a lawyer from making a communication that states or implies that the lawyer is able to provide legal services in a language other than English if that's actually not the case. 7.1 and 7.5 of the rules of the new rules of professional conduct are not exclusive means by which the regulation or advertising may be regulated. It cites to the Business and Professions Code that deals with these issues. 7.2 is specifically intended to address advertising and describes what is permissible. Advertising standards are described. You're allowed to pay reasonable costs associated with that, with advertising, as well as you may participate in legal services plans if that is applicable. Allows for the purchase of a law practice, allows for the use of qualified legal referral services and referral to lawyer or non-lawyer professionals pursuant to arrangements that don't result in fee sharing. And then we're going to just briefly touch upon 7.4 and 7.5, which are essentially subsumed in to 7.1 and 7.2, dealing with legal specialization. Again, if one is a certified specialist by the Board of Legal Specialization, that may be represented. However, you can't claim to be something that you are not. And then similarly with 7.5, you cannot violate 7.1 by making certain representations that are inaccurate or misleading with regard to your association with a particular law firm.
So one thing that's interesting about this new set of rules is, number one, that they use the word advertising, which is a little bit confusing because the State Bar Act advertising rules typically apply only to advertisements that you pay for. So if you're not out there actually paying for advertising, the State Bar Act may not be implicated. But now here we have the Rules of Professional Conduct also using the same language now, advertising, but they may be implicated, the rules, because the paying for the advertisement is not a requirement to trigger these rules. So you know, it's hard to listen to advertising you know, rules sometimes. It's like, I don't advertise, I don't need to worry about it. But you know, do you have a website? Do you use social media? If anything, that you're using to promote your practice, whether or not you're doing it to you know, paying for it or not, do you use Avvo? Have you claimed your profile on Avvo? These are all things that you have to make sure are truthful, that you know, if you're using them to promote your practice in any way, you will trigger the rules of professional conduct, even if the advertising rules of the State Bar Act may not be triggered at the same time.
And just to follow up on that point, that reference that Suzanne made to social media is particularly important with regard to, there's not currently any obligation to search out third-party sites that may contain information about you. However, if you take affirmative steps to adopt a profile, for example, let's say by linking it to your own firm website or by referring to it in your own materials, then that does impose a duty, arguably, to comply with the advertising rules because you have taken affirmative steps and you're aware of the content, presumably, of that site to which you've linked, that third-party site. That imposes a duty upon you to ensure that so long as you maintain some connection or affiliation or allow for citations to that site, that it is factually accurate and there's not misrepresentations. And that can become very complicated and thorny, in particular with sites that don't allow for the attorney referenced to make affirmative changes. Let's say that there's some third-party reference that's included, say from a former client, that contains factually inaccurate statements. The licensing agreement of the third-party site may not allow you to make changes or corrections. So in that circumstance, you may have an obligation to abandon any link to that site so that you remain compliant in that situation.
Okay, what's probably apparent to everyone is that we've gone from a single rule addressing both advertising and solicitation, marketing of a lawyer's services, to 5 separate rules. In other words, we've adopted the Model Rules Organization. But that's the Model Rules Organization only up until August of this year. Because notwithstanding the fact that finally, after decades of the ABA trying to convince California to move over and adopt the ABA model rule numbering system and organization, California probably finally did it. And what did the ABA do? They stuck it in California's eye. They revised their advertising rules. They moved rules 7.4 and 7.5 into 7.2 and 7.1 respectively, as Eric noted, moving the 7.5, or 7.5 deals with firm names and letterheads. That's just an example of false and misleading advertising if you're using a also misleading name for your firm, or you have a designation like on your business card. It's just an example. So they have folded the provisions of what used to be Model Rule 7.5 into Rule 7.1. And they then took Rule 7.4, which deals with lawyer certification and fields of practice. What are those? Those are just one form of advertising. How you hold yourself out to the general public. They have been folded into Rule 7.2, which is titled advertising. Although 7.2 deals with a lot of other things, as Eric mentioned, because it also deals with payments for advertising or payments for recommendations. That's going to be, you'll find that in 7.2b. So California, finally a good soldier, and the ABA stuck it in our eye in the process. But now I'm going to talk about Rule 7.3. Again, we pretty much adopted what was ABA Model Rule 7.3, and what did ABA do? They pulled the rug out from under us, and they made some significant changes. And I just want to emphasize these changes primarily so that you understand that they don't apply in California yet. Probably this is the direction in which California will eventually go, but they have not yet been adopted here. Okay, so what do we have? We have subparagraph A talks about in-person solicitation. Well, what do they mean by in-person solicitation? They mean live communication with a person who is interested in legal services, might have a particular issue of which the lawyer is aware, and the lawyer is going to try to convince the person to hire the lawyer. No, I'm trying to avoid using the term prospective client, because prospective client is now defined. It's a defined term as a person who has consulted with a lawyer for the purpose of retaining a lawyer or acquiring, receiving legal services. So it used to be prospective client was used throughout the advertising rules, but that's been eliminated. In-person solicitation, it can be in person, live in person. You knock on somebody's door, you go to their hospital, I know you don't do that. Scene of an accident and so forth. A live telephone solicitation, or what California has now adopted, a real-time electronic communication. The concept being there's something like a chat room, or I don't know if they do it anymore, the old AOL instant messaging. Yes, you still have that. Texting, no, that wouldn't quite qualify, because texting isn't something where you're actively going back and forth. It can be, but not necessarily. But real-time electronic communications, what did the ABA do? The ABA eliminated that. And now what the ABA uses is a single phrase. Rather than talking about in-person telephone, it is live, in-person contact. That's what the ABA uses. But we here in California retain the descriptive, the three different categories: in-person, by telephone, or by real-time electronic contact. Okay, now there are exceptions to that. First, can you solicit the business of a lawyer? Yes, you can go to another lawyer. Why? What's the whole concern about live solicitation? I'll tell you what. We, everyone in this room, no matter how inarticulate we may think we are skilled in the persuasive arts. And therefore, other people, non-lawyers, they're putty in our hands. We can convince them to do anything. And so we are prohibited from soliciting them. Now, there's a early 1990s United States Supreme Court case which said, may accountants, it's Edenfield, E-D-E-N-F-I-E-L-D against Fane, F-A-N-E, which said that accountants can cold call prospective, the public seeking business, because they are not skilled in the persuasive arts, like lawyers. So we always thought that what the Supreme Court is telling us, whoa, beware of lawyers. And no matter, even if you're communicating with a sophisticated person, experienced in the use of legal services, you simply can't do it. But a lawyer knows your tricks. You're not going to be able to pull the wool over the eyes of another lawyer. hope that's true. Okay. The other one is you can communicate with family if you have a family relationship, a close personal relationship, or a business relationship, or a professional relationship. You can communicate with the person by telephone, in person, or by real-time electronic contact. That's an exception. Now, the American Bar Association recently took the Aidenfield against Fame permission for accountants to communicate with a business person, another business person. They took it around with it. But again, we are not the ABA, we're not the model rules. I'm just going to mention this exception, but it does not exist in California. It specifically applies if it is a person who routinely uses for business purposes, business purposes. This isn't like someone who routinely might hire lawyers because they're a litigant, they like to litigate or something, but it's for business purposes. The type of legal services on offer by the lawyer, you can contact that person in person, by telephone, real-time, electronic. That's going to be in an ABA state. If you're licensed in another state and you are looking for business in another state that has adopted the ABA model rules, you'll be okay. But remember, these aren't the rules of any other jurisdiction until the jurisdiction explicitly adopts them. The ABA model rules are not the law. They are simply a model code of rules. And they only become law that regulate lawyers if they're adopted by a particular jurisdiction. So the ABA has that, we don't have that, but that is the exception. Now, paragraph B talks about other kinds of solicitations. And this is, it doesn't have to be in person, they can be written solicitations. Heck, they could even be a billboard for all intents and purposes. And you're still prohibited from sending out that solicitation or making that solicitation if the target audience has, quote, made known, close quote, a desire not to be contacted by a lawyer, or if you're using your solicitation is transmitted in a manner that involves either intrusion, coercion, duress, or harassment. This whole concept, are you intruding on a person? Might you be coercing the person by making your bid for their business? Are you harassing the person? You simply can't do it. Paragraph C just talks about the labeling requirement. I've talked to a few people before our program began today. Ultimately, I think the labeling requirement, even though a lot of people say it doesn't make sense because how many communications are made by letter? I probably receive several letters every week that look like legal announcements that don't say they're advertisements, that might be from lawyers, and they don't have the thing that says advertisement. I know that these aren't actual legally binding things, but what the heck, someday I'm going to get served with summons, and I'm just going to throw it out, because just say, oh, this is just junk mail or something. And there'll be a default judgment against me, and I'll be reported to the state bar, and I'll be in trouble, but hey, so it goes. I think this is not that bad a thing. Yeah, what do you do? Does this mean you have, I think the ABA eliminated this requirement. They did recently eliminate the requirement in their model rule, simply because they said it's really difficult to do it with electronic communications like text messages and so forth. Well, so it goes. I don't think it's a bad idea, particularly when you're dealing with a regular envelope. And then paragraph D talks about, yes, you can participate in a prepaid legal plan. For example, the union has a prepaid legal plan, even if that prepaid legal plan engages in in-person solicitation of persons who are not part of the exception to the in-person solicitation. In other words, they're not family members, they're not another lawyer. It's okay for you to participate in that, as long as it's not another lawyer in that prepaid organization who's doing the soliciting. Remember, still in the persuasive arts, we got to protect the public from those lawyers and their persuasive skills. And that's pretty much Rule 7.3. It's very similar to the ABA. The ABA rule has expanded. It has an added exception. Now a business person who regularly uses legal services can be solicited in person. And they also have the deletion of the advertising requirement. California very much has the advertising requirement. And even if California were to get rid of it here in 7.3, always beware, we still have the Business and Professions Code with its own requirements.
This one is also another one, 7.3, that has its own special definition embedded within the rule. So again, we see an example there at subdivision E, how sometimes the definitions that are applicable are in the rule itself. Not all definitions are in 1.0.1, just to keep you on your toes, so you have to keep looking for those asterisks. Okay, we'll speak next about the rules governing maintaining the integrity of the profession. And these have to do with misconduct generally, which there is a present articulation of this requirement in our rules. Prohibited discrimination, harassment, and retaliation. This is also in our present rules, but there's been a very significant change made to this rule, which Teresa will discuss. And disciplinary authority and choice of law. And also the question that everyone always has is, what happens if my conduct occurred before November 1st? And what happens after? Eric, even though it's not particularly in that rule, he will discuss when do these rules, do they apply retroactively, do they apply prospectively?
Okay. First one is Rule 8.4, and formerly 1-120, and frankly 1-120 was very general and very short. Basically, you were prohibited from inducing a violation of these rules. But 8.4 is, as you can see, much more complete. Now, interestingly enough, there's not one of these conducts that bullet pointed here that would not have been actionable prior to the availability of the new rules. They would probably have fallen under the D&P code, such as D&P code section 6106, which prohibits moral turpitude, whether or not it involves criminal behavior, or D&P code 6068, under its many subsections, and under one or more of its many subsections, which define the duties of the lawyer. This is 8.4 is valuable in that it takes some very, very common types of allegations and it gives them some specificity and a few asterisks so you can define them. But in terms of whether they were ever allowable, no, they never were, and they were actionable before. This just gives a greater definition and a lot more guidance. Rule 8.4.1 is perhaps one of the most, has caused some of the most greatest conversation. It was a rule that was ahead of its time when it was first adopted about discrimination and harassment and retaliation. There are some things it did not originally include. For example, it was confined to the running of a law firm, so it did not expressly address whether or not discrimination could be exercised toward clients. There were, in addition, retaliation was not specifically included in it. There were some protected categories of people involved in this, but those protected categories changed over time in California law. And as a result, it didn't include all protected categories that were in California law. So somebody who was protected from discrimination under California law might not have been protected under this particular rule. But most importantly, I think, and this is what caused a lot of the heartburn, and it was its disciplinary effect. And as of the original rule, 2-400, did not allow the imposition of discipline unless another tribunal had already reached a final decision, I mean through appeal, as to that conduct constituting harassment.
Under this rule, the state bar can proceed with the investigation and prosecution of an unlawful discriminatory act. And unlawful is a very important point here, because it does not define discrimination. It requires the state bar to identify some unlawful behavior, and unlawful as defined by some body of law. So in other words, the state bar, in order to prosecute this, would have to prove to a clear and convincing standard, which is the standard that's required before the state bar court, that all of the elements of some body of law proving that this conduct was discriminatory were present before it can prosecute. That, or before it can have culpability found. It is only after that can discipline can be imposed. That said, the discipline can be imposed whether or not there has been another proceeding brought, and it does not have to wait till that other proceeding is concluded. So now there is a great deal of concern that the state bar will go on a tear on prosecuting discipline, on discrimination, harassment, retaliation. And I just could tell you from my own experience that the state bar doesn't have that kind of time. So I don't think that you're going to see a big influx of cases on this or investigations on this. If the state bar also has a very heavy burden of proof and must use outside law in order to prove these allegations. So it still has significant hurdles before it can reach discipline on this particular allegation, on this particular group.
Okay, I just wanted to add something. Again, you're listening to the risk-adverse guy up here, who also agrees with what Teresa said. It's still unknown exactly how this rule is going to play out within the discipline system. The other rule, I don't believe there was ever a prosecution under Rule 2400 because of the prerequisite that there be a judgment having been obtained from a court of competent jurisdiction. However, there is an opening that the state bar could investigate, that the state bar is no longer manacled and prevented from actually opening an investigation or holding a proceeding on a matter dealing with discrimination. So assuming that happens, I just wanted to emphasize something. At minimum, read comment 1 to this rule because it points out some very important factors. First, this ties in with Rule 5.1 and 5.3, the obligation of a lawyer to supervise. So it doesn't mean, remember, you're not going to be disciplined for failure or disciplined for vicarious liability, but you will be disciplined for your failure to supervise or failure to take reasonable actions. In other words, if you look at 5.1a, you're supposed to have reasonable measures in place. What are those reasonable measures? We don't know what the reasonable measures are yet. That's going to play out in the discipline system. It might be you have written policies. Well, how good are written policies if they're not read? You might have to have training sessions. You might have to show that you have made an effort to educate your staff and subordinate lawyers about this rule. And that's going to be important because Rule 1.1 says this rule applies to all firm lawyers, all lawyers in the firm, not just the supervisory lawyers. That's it. If you see something, do something. In other words, you essentially says a lawyer. It doesn't say supervisory lawyers are prohibited from knowingly permitting it. It says all lawyers. It says any lawyer is may not or shall not knowingly permit. If you look at both paragraphs, look at paragraph B. And it's in relation to the operation of a law firm. It doesn't say in operating a law firm or in managing a law firm. It's not speaking to the managers. It's speaking to all lawyers in the law firm. So please, everyone keep that in mind. Now, the last sentence of comment 1 at least says that, well, you can't charge the victim of discrimination for knowingly permitting the discrimination. If they decide that they're not going to file a complaint, they can't be charged for knowingly permitting. That's a clarification to comment 1. So please, when you're reading these rules, look at the comments. This rule in particular, please look at the comment. Again, I agree that the state bar is overburdened in terms of its running all the other rules that it has to run. It has the ability to evade a proceeding and let the proceeding proceed in civil court. But again, what if that doesn't happen? What if the state bar does pursue an investigation and opens a proceeding or holds a hearing involving a lawyer? These are the duties that you have under the rule. It's not just supervisory lawyers who do this.
All right, next we will cover disciplinary authority and choice of law issues. It's interesting that this particular rule is now at the end of the rules of professional conduct, whereas before it was part of 1-100D and was more definitional in sense. So much of the substance of this particular rule carries over from its antecedent. It does recognize the changing dynamic of our profession in terms of lawyers practicing in multiple jurisdictions. It specifically provides that a lawyer that provides or offers to provide any legal services in California may be subject to discipline in California. Now, as a practical matter, unless the attorney is admitted, say for example, pro hoc vice, there's little enforcement authority that could practically be exercised, but nevertheless does include that language. Subsection B of 8.5 deals with choice of law. If it's a matter involving a proceeding before a tribunal, then the rules of the jurisdiction where that tribunal sits would apply. For other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred. So that encompasses not just actions that are strictly within the ambit of the professional duties that we're discharging, but also actions that would otherwise subject one to potential discipline, but that aren't specifically within the rules of professional conduct, what used to be known as acts of moral turpitude or things of that sort. And then lastly, I know there was Suzanne alluded to when these rules become effective on November 1st, will they be interpreted retroactively or prospectively? The view is prospectively. However, should note that there has already been a decision that refers to 1.18 that came out, it was early this week, I think, yes, Monday or Tuesday, that is already interpreting the new rules even though they have not taken effect. So keep that in mind going forward and govern your conduct accordingly. And so with that, we're going to have Kevin talk a bit about what hasn't changed with regard to the rules and laws governing our practice.
Okay. Thank you, Eric. At the beginning of our program session, I mentioned that the rules are not the sole source of lawyer regulation. And they aren't. We still have the State Bar Act. We have other statutory provisions. We have a very rich case law in California regarding the law of lawyering. I just want to speak to a few of the things that haven't changed. The one that I'll spend the most time talking about, but I hope it's not going to be very long, is Section 6068. These are the duties of an attorney. Many of the provisions are taken from the original field code, which was adopted by the California legislature back in 1872. Teresa already made mention of 6068 subdivision E, which is the duty to maintain and violate the confidence that every parole to himself or herself to protect the secrets of his or her client. That's our confidentiality rule. We're the only jurisdiction that has confidentiality in a statute. Case law can't change the statute. The rules of professional conduct can't change the statute. There was no exception to the duty of confidentiality for 132 years until 2004, when, or it was actually the fall of 2003, when the legislature, effective July 1st, 2004, carved out the single exception for a life-threatening criminal act, death or substantial bodily harm. We can reveal a client's confidential information to prevent a criminal act reasonably likely to result in death or substantial bodily harm. It can't be done. So that's why Rule 1.6 is remarkably similar to soon-to-be former Rule 3100. It's virtually unchanged. It's also the reason why we don't have Rule 1.14. That's the client with diminished capacity. With trust and estates lawyers have been pleading with the Commission for about the last 17 years to please come up with a rule. And we did come up with a rule within the constraints I just mentioned. Since a rule of professional conduct cannot carve out an exception to confidentiality, then typically, what are you going to have to do? You're going to have to reveal confidential information of your diminished capacity client in order to obtain the necessary help for the client. It's an unfortunate situation. The problem is there is no exception in 6068E, so the Commission drafted a rule within those constraints, and the Supreme Court rejected the rule because it was a very complicated rule, which a lot of people from the public comment we received didn't completely comprehend how it was supposed to work, and frankly, I think some members of the Commission were not sure how effective it was going to be. The Commission did its best job, but the Supreme Court decided it was not a place it wanted to go. So probably within the next year or two, you will see a proposal to carve out another exception of confidentiality to protect perhaps the financial interest of a client who has diminished capacity. You might see that happen then. As far as the moral turpitude, dishonesty, corruption, regardless of whether it's a criminal conviction, 6106, it's a provision of the Business and Professions Code that a lot of lawyers are not even aware of. Yet if you look at any of the state bar court decisions, it is going to be one of the bases for discipline in nearly every case. It's one of those things where nobody really knows it's there, but it's essentially the Swiss Army knife of discipline. It can be cited for just about any conduct that was involved in. And the state bar does not hesitate to cite it, even though it's the same conduct, it comes under another rule. And usually what the state bar court will do is it will dismiss the other charges and then impose discipline under 6106. Finally, all the advertising rules. We just mentioned, we just went through Chapter 7 of the new rules of professional conduct on marketing, advertising, and solicitation. And yes, they're new, there are some changes, but you always have to remember we still have duties under 6157 except. And there's one important point that I neglected to mention before. The requirement that you retain a copy of your advertisements for 2 years in the current rules, soon to be former rules, has been removed. But there is still a requirement in the Business and Professions Code that you retain those for 1 year after the last time that they have been disseminated over whatever media, whatever public media you're using.
And just further on that point, on the 1.14, that circumstance that Kevin was talking about, and the estate planning attorneys that are begging for it, or what can they do in a situation where they think their client has some diminished capacity and that they are being taken advantage of by maybe a relative, or either financially or emotionally, what can the lawyer take steps to get a conservatorship in place? Can the lawyer take steps to protect the client? And if revealing some confidential information is necessary to do that, can they do it? And under the model rules, under limited circumstances, you can if you're taking protective steps. It is an exception to confidentiality. We don't have it here because, as Kevin says, it's not in the statute, and the commission came up with something in between, but the Supreme Court didn't embrace it. And it was kind of cold comfort, but it was something better than nothing, I think. And so we're left with nothing for now. The other interesting thing about 6106 is still in place, and it prohibits lawyer dishonesty. And one thing that I've always thought is interesting about it is that it prohibits lawyer dishonesty even if you're not acting as a lawyer, even if you're not in the process of representing a client, you can't act dishonestly. Even if you're just being a regular average citizen out there, the fact that you're a lawyer, you're held to a higher standard. So something people don't always know about. If you have any other comments, I'm not going to hit the prosecutors. I'm just going to open it up for questions.
Yeah, the only point, I advise my students to do two things the night before they take the bar exam because of the higher standard to L2. First, I advise the students, don't study. It's too late at that point. Second, do something illegal. But I did, I jailed on Riverside where I stayed for exam, and I felt empowered. Okay.
Live it on the edge. So we did want to leave an opportunity for questions. If anyone has any, please go ahead and raise your hands.
There were standards for advertising. Are they abrogated? Do they still exist?
Standards as standards no longer exist. Okay. They have been removed, but many of the standards have been moved into either the black letter text of the advertising rules or into the comment. But as a presumption of a violation, they no longer exist.
Yeah, and one of the most significant ones is on the disclaimer, you know, where you have to put a required disclaimer now, otherwise you're presuming a violation of the rules when you're using endorsements. Now the disclaimer is suggested, but it's not going to be presumptively a violation.
Yeah, and one other point on that is the Board of Trustees has still been authorized to promulgate standards. So we may see new standards, or we may see some of the old standards coming back in the future. But right now, on November 1st, there will be no standards as presumptions of violations.
Any questions? Well, thank you all again for coming. You were jumping the gun on this and really getting on top of the disclosure. Thank you very much.